Hello, this class is mainly about independent living, assisted living, and continuing care retirement communities. But first we're going to finish up something from the last class, namely the question of pre-dispute arbitration agreements in nursing home contracts. I couldn't fit all of that into the last class. Unfortunately, we have some extra space here. Pre-dispute arbitration clauses in the admissions contract to a long-term care facility are an agreement in which the parties, that is the facility and the resident, that an agreement that should a dispute ever arise, it would be settled by arbitration rather than through the courts. Remember that in the context of nursing homes, we read about lawsuits against nursing homes when a resident was harmed as a result of the home's failure to provide proper care, and most often the basis of the suit is breach of contract or negligence. Sometimes wrongful death, but the only people who can recover under wrongful death are very close relatives, specifically the spouse. Page 425 of the text was left out of the reading by my mistake. It's the introduction to mandatory arbitration agreements, and it explains that these agreements bind the parties to submit their dispute to a neutral third party rather than going to court. And as the book points out, arbitration is usually good for the nursing home rather than for the patient. It's good for the nursing home because it's less public than litigation in court, and it results in lower damages for the plaintiffs. Now, throughout industry, there has been a move towards mandatory arbitration agreements, and this is not an unwelcome development for consumer law. These arbitration agreements are almost inescapable. Almost every credit card company has mandatory arbitration clauses. So does Amazon, so do many employment contracts. Arbitration agreements are particularly targets of the Me Too movement because offenders are never exposed, as it were. So their wrongdoing goes under the radar, publicly speaking. Now, there is a strong federal policy in favor of mandatory arbitration clauses in contracts generally. They're spreading throughout the contract world, and that federal policy is expressed in the Federal Arbitration Act. States, on the other hand, especially liberal states, are hostile to arbitration agreements, or mandatory ones anyway, and especially to mandatory clauses in nursing home contracts. And this slide shows you an explanation from the ABA about why arbitration agreements are especially troublesome in the nursing home setting. Nursing homes say, in effect, if you don't like this agreement, you can always go to the nursing home down the road. Now, that's wrong, not to mention laughable, for two reasons. First of all, arbitration agreements are so widespread that you're not going to find one that doesn't have an arbitration agreement. And second, the idea that you can go down the road to another nursing home is a joke in large parts of America because the nearest nursing home might be 100 miles down the road. So basically, families entering into this contract with the arbitration clause are both particularly vulnerable because it's a moment of crisis and they need help immediately. And secondly, they are in essence forced to sign because they have no other choice, no other options. The Howell case concerns an arbitration agreement in a nursing home contract. And the court here says the agreement in question was a contract of adhesion. That is, the customer has no opportunity to negotiate. His choice is take it or leave it. And the court says there's nothing wrong with that except if what? That's what the true-false questions are about. So you answer those. There is a long history of decisions in the courts about arbitration agreements in nursing homes, and there are also in many states statutes on point. But changes in the regulations of the Center for Medicare and Medicaid Services have left the status of arbitration agreements up in the air, as we'll see in the next slide but one. In recent years, challenges to arbitration courts in the states have succeeded on the basis of unconscionability, the agent's lack of authority to bind the principal, and state remedies. California, for instance, had a rule requiring contracts to state in boldface that signing the agreement was not a requirement of the contract. And here is New Jersey's very consumer-friendly statute on point. All arbitration agreements in nursing home contracts, that is, all waivers of the right to sue in court, are, quote, void as against public policy and wholly unenforceable. As of October 2019, this New Jersey statute is, or was, still good law. However, see the next slide for recent changes in the CMS regs that have changed or may change everything. In 2016, the Center for Medicare and Medicaid Services banned pre-dispute arbitration agreements in nursing home contracts. Not allowed. Then something happened between 2016 and 2017, a change of administration or something. First, the Center for Medicare and Medicaid Services proposed lifting its ban, the one it had promulgated just a year before, in exchange for something that it called transparency. That is, the agreements would be valid providing that the resident was thoroughly aware of what he was signing. And then there was pushback from advocates for nursing home residents. Finally, in July 2019, the CMS issued its final ruling, which I've reproduced here. Arbitration agreements are allowed, but nursing homes cannot make them a condition of admission, and indeed the nursing home must tell the resident that he or she does not have to sign and will be admitted either way. And furthermore, the resident has a 30-day window to rescind his or her agreement. Why would the nursing home even want such a rule, given that the residents can just refuse to sign? Well, I don't really know where the nursing homes stand on this rule, but I guess they count on some participants just going along with the deal and not understanding until the 30-day period has elapsed what they've signed away. The ABA says of these new rules, let us, that is, us lawyers, set our sights on reaching a 100% refusal rate, and then we could achieve a ban on these agreements through consumer action. I'm afraid I forgot to say something important on the last slide. It looks as though the new CMS regulations will preempt state regulations on arbitration clauses, so that New Jersey's very strong protection for nursing home residents will be preempted by the CMS ban. But this hasn't been litigated yet, so there hasn't been an official pronouncement, and we're a little bit in limbo as to what the protections are for nursing home residents in New Jersey. Okay, interlude music. Now we start on the main topic of today's class, which is independent living, assisted living, and continuing care retirement communities. So, little background. In previous classes, we read about how care for the elderly changed beginning in the 1970s and 80s. There was a general move in the United States to deinstitutionalize people in need of care and integrate them into the community. And at the same time, not coincidentally, seniors began to demand less hospital-like settings. And that was true even within nursing homes, as we saw last week. The nursing homes of the 50s and 60s and 70s were not homes. They traditionally offered shared rooms, unlockable doors, minimal privacy, little or no independence. And it was the Omnibus Reconciliation Act of 1987 that granted nursing home residents rights including self-determination, person-centered planning, some degree of privacy, and so on. Another part of the Omnibus Budget Reconciliation Act allowed states to apply for a waiver from Medicaid requirements at the time. The requirements at the time said that Medicaid would only pay for care in a nursing home, in an institutionalized setting. These waivers allowed states to provide care to Medicaid recipients through home and community-based alternatives to nursing homes, including, oh, there go my lights, care in the elder's home, which is aging in place, which we covered 2 weeks ago. So I want to stress again that these waivers allowed for Medicaid support for care within the community. Among the options we're looking at today, so we've moved beyond care in the home and we're looking at care in facilities. Independent living does not involve care. It's merely an apartment in a complex with amenities. Assisted living facilities do offer a range of services short of nursing homes, as we will see. And as to continuing care communities, these are a 3-in-1 arrangement. The same facility has one part devoted to independent living, another to assisted living, and finally a portion devoted to a nursing home. And the attraction of this arrangement is that you can move in while you're fairly healthy and know that as you get sicker, you're not going to have to move out to another facility. And especially interesting to people is that if one spouse gets sicker, the healthier spouse can continue to live in their old apartment while the sicker one moves a few floors down, someplace where the healthier spouse can still visit. So this picture is supposed to illustrate everything. It shows a continuing care retirement community in which a few floors are devoted to independent living, a few to assisted living, and there's also a floor that has a nursing home facility. This slide is very self-explanatory, so I will leave you to read it for yourself. This slide is a total frivolity. Danny House, this is where I want to live right now. So I look at this manor house and I think being an aristocrat means you never have to run your own bath. You can watch the advertisement to make you feel better about old age, and to make it even more attractive, Danny House is not wildly expensive. It costs from about $2,200 per month for a studio to $5,400 for a 2-bedroom apartment, and compare that to the $5,000 that my father paid for his 1-bedroom apartment, which really was just 2 very small rooms in his assisted living facility in Minnesota. Well, as you see here, assisted living is not a term of art, and it's not defined by regulation the way a nursing home is. But the way we're going to use it here is as defined on page 437, a long-term care option that combines housing support and, if needed, help with bathing, dressing, incontinence, and so on. And you should recognize those as the activities of daily living that are among the medical requirements for Medicaid payment for nursing home services. In fact, the reason that the nursing home population is shrinking is that the least sick are staying in assisted living facilities. Assisted living facilities are to some extent the new nursing homes, but they are less heavily regulated at the federal level, and therefore we're going to shift now to state regulations for our discussion of assisted living. Okay, just a technical matter. You remember that a few weeks back I mentioned that under the 1915 C waivers, the Center for Medicare and Medicaid Services may waive certain requirements to allow state Medicaid programs to cover home and community-based services, or HCBS. So assisted living facilities fall under this heading of home and community-based services, the goal being to provide full access to the benefits of community living and other services in the most integrated settings possible. This picture is of charity housing for the elderly in the Netherlands in the 17th century. A donor left his entire estate to serve the poor and built this really very charming, I guess you would call it an independent living facility for elderly women. Do you have the feeling that I'm thinking of every other possible arrangement than ending up in an assisted living facility for myself? Danny home, the 17th century, get me out of here. A private pay patient in an assisted living facility can convert to Medicaid if that person meets all of the Medicaid requirements, that is over 65, needs assistance with at least 3 activities of daily living, and has run out of money, so meets the financial requirements. However, a resident is not guaranteed a place in the assisted living facility, as he or she would be in a nursing home. It all depends on whether there is a Medicaid bed free for that person, and that's the subject of the next slide. So here's one of the areas where assisted living facilities fall between 2 stools, between the federal regs and the state regulations. The federal government granted waivers for states to use Medicaid funding for assisted living, but it did not create regulations for assisted living facilities. And in particular, it did not impose a requirement that residents would be allowed to convert to Medicaid when they ran out of funds. That was left to the states, and the states were lobbied by the assisted living facility industry to create a Medicaid bed requirement. I don't really understand why they did that. So the New Jersey regulations are that all assisted living facilities established after September 1, 2001 must have a Medicaid eligible population equal to 10% of the facility's total population. So a newly established assisted living facility has to set aside 10% of its beds for Medicaid residents, and any assisted living facility that expanded its beds after 2001 had to set aside 10% of the extra beds for Medicaid patients. There's no other requirement about about accepting Medicaid patients, and the assisted living facility may formulate its own policies about who it's going to accept and who it won't. And it might, some assisted living facilities do have a private pay requirement so that they favor or they require patients to use to pay out of pocket for some amount of time before they will be accepted on a Medicaid waiver. I think you can see the bottom line here. You're not going to get into a good assisted living facility as a Medicaid patient. And if you have to leave an assisted living facility because you are ejected for some reason, you're going to have, and if you're then dependent on Medicaid, you're going to have trouble getting into another good assisted living facility. All of that doesn't matter to people who have so much money that they don't ever have to worry about Medicaid eligibility. But if you see the possibility of Medicaid on your horizon, you should be careful in selecting your assisted living facility and in looking at your contract to make sure that you will be covered if you eventually have to switch over to Medicaid. So the tips here are if the facility makes you an oral promise that you can convert to Medicaid, don't let it stay at an oral promise, have that converted to writing. Read any Medicaid disclosure statement in the contract to make sure it doesn't contradict what you just got in writing. You could ask if the facility was licensed after 2001, because that means that they have to put aside 10% of the beds, and be sure that you understand what it takes to be Medicaid eligible. Right, one more slide after this. Okay, this is a slide that I could have included in a much earlier class. It's about when to apply for Medicaid. You don't want to wait until the very last minute, because then you might have no coverage while you're waiting for the state Medicaid office to process your application. Not that you'll be kicked out, but it's a very uncomfortable situation to be in. Therefore, residents are encouraged to apply up to 180 days before they are financially eligible. And indeed, we saw a lot earlier that if you see Medicaid on your horizon, you might want to get the snapshot, that is, sort of declare your interest in Medicaid at a very much earlier date, so as to preserve assets for the community spouse.